We'll start the meeting. Can everyone hear me okay, first of all, before we start? John, can you give me a wave, Mr Campbell? Great, thank you. My name is David Liddell. I'm the reporter appointed by Scottish Ministers to report to them on the planning appeal by Loch Long Salmon Limited, the proposed Fish Farm Act. Reithe, is that the correct pronunciation, or is it Reithe? Okay, thank you. So also with me today from DPEA are Callum Henderson, who's at the back, dealing with the IT and webcasting for the meeting, and Jane Anderson, who you will have met when you come in. And Jane's the case officer responsible for the administrative handling of the appeal. You should have all have been emailed an agenda for today's meeting, and the paper copies on your seats there. So before we start, I'll just do the usual announcements about housekeeping. There's no fire drill planned or test, so if the fire alarm goes, there's the fire exit there, and the muster point is in the car park. The toilets are behind me, if you go out that corridor and round behind the stage. It might get hot in here. I was expecting a lot more people in the room, so it might not get as hot as I was anticipating. But we've got some water here. You please use that. We can take a break if people need to. And if you can all have phones and devices to silent, please. If you need to leave the hall for an emergency or for whatever reason, that's fine. You just do so. The final thing, yes, Wi-Fi for anyone that needs it. There is Wi-Fi in the hall. The details and password are up on the wall over there. Okay, so usually at this point I'd ask everyone participating in the meeting to introduce themselves. Normally we'd all be sitting in a round table format, but by some margin I was expecting this to be the largest group of people that I've ever had at a pre-examination meeting. There were about 45 individuals and organisations that said they wanted to take part. There seems to be fewer of us, but I'll just stick to my plan. I thought it wasn't going to be practical to ask everyone to introduce themselves, but I'll hopefully hear from you during the course of the meeting. So we've set up the room so that those here from Loch Long Salmon, because this is their appeal, and those here from the National Park Authority, since it's their decision that's being appealed, are at the front and can introduce themselves to you. So hopefully all those of you who are here have registered your attendance with Jane as you come in. If you haven't, please just do so at some time before leaving. Now, usually a pre-examination meeting would be finished in the morning. It might be that we need to break for lunch and come back in the afternoon, depending on how much progress we make, particularly since there are quite a few of us, or certainly I was expecting quite a few. And most of the questions I have, at least initially, will be for the two parties at the front here. But please be assured I don't want to exclude anyone from participating in the meeting. I will at each stage stop, make sure that anyone else has a chance to contribute. Anyone who wants to contribute has a chance to do so. And if I forget to do that and you want to say something, then please let me know. And that applies equally to those here in the room and those on screen. Many of you might benefit from a brief explanation from me about how the appeal process works and the purpose of the meeting today. I'll move on to that in a moment, but firstly, I'll ask for introductions from the parties here beside me, first of all. So, final housekeeping point. Everyone participating in the meeting and those remotely should be aware that the meeting is being webcast and recorded. So by participating, you're agreeing to being recorded and to the use of that information for purposes including staff training and making information available to members of the public. And the recording of the meeting will be retained for viewing on our website. So to operate the microphones here in the room, you just press once to turn on, and the red light should come on, and press again to turn off when you've finished speaking. And it's essential that we all do that, particularly since this is a hybrid session. It just makes those participating remotely better able to hear what's going on, and also for the webcast recording, if we just have the single microphone in use at any one time, then that makes that recording clearer. So if we can all try and remember that, please. There are some speakers in some of the which switched on in some of the seats, so you shouldn't need to do anything with those. Hopefully that's providing a bit more audibility. And if we're moving the microphones around, if we can do it like that rather than holding the stem because they're a bit delicate. So, if we can do the introductions then for the appellants first of all, please.
Thank you, sir. Good morning. My name is Craig Welton. I am a partner at Burgess Salmon Solicitors, and I'm representing the appellants. I'm joined, if I go down the line, to my immediate left is my colleague, Mr. Patrick Munro, and then to his left are Mr. Stuart Hawthorne and Mr. Mark Shotter of Loch Long Salmon, and behind me is Mr. Joshua Holder, also of Loch Long Salmon.
Okay, thank you very much, Mr. Welton. And for the National Park Authority, please.
Good morning, sir, and all participants. My name is Alistair McKee. I'm a partner at the law firm Anderson Strathern. I'm representing the National Park Authority today. The gentleman on my right is Stuart Mearns, who's the Director of Place, and the lady on my left is Alison Williamson, who is a planning officer with the park.
Okay, thank you very much, and apologies if we have given you a dud microphone. But you can maybe switch them over if needs be. Okay, so how does all this work? There's been an appeal to the National Park Authority's decision to refuse planning permission, and that right of appeal is to the Scottish Ministers. Now, normally appeals are delegated to someone like me. I'm a reporter from the Scottish Government's Planning and Environmental Appeals Division, and the reporter then makes a decision on the appeal. Ministers can, if they wish, though, decide to determine an appeal themselves, and that's what they've chosen to do in this case. So therefore my role changes. Instead of deciding the appeal, I need to write a report to ministers, in effect to the Planning Minister, Joe Fitzpatrick, and this will contain my assessment of the planning merits of the proposed development and a recommendation on whether or not I think the appeal should be allowed. Ministers don't have to follow my recommendation. They can reach a different view if they want. And often a reporter will be able to write the report without gathering any further evidence from the interested parties. However, in this case, there are a few areas where I think I need further evidence, and I've set out my initial thoughts on these under item 3 of the agenda, and we'll come on to that, including what procedures I think may be best for each of the issues I've listed. So, part of the purpose of today is for me to hear your thoughts on this. For each issue I've raised, what's the best procedure? Written submissions, a hearing, or a public inquiry session. And are there other issues that I've not identified where people think further evidence is required? But there's an important point to be made about that. The only purpose of having further written submissions or a hearing or an inquiry is to provide me with the information I need to write my report. I have a lot of evidence already, including all the consultation responses, all letters of objection to and support for the proposal made to the Park Authority, and subsequently to DPA after the appeal was made. So I want to hear your views today about the gathering of further evidence, but ultimately if I think I already have enough information on a particular matter, then I won't be looking for any further evidence on it. And after the meeting, I'll send out a note confirming my decision as regards the further procedures and asking everyone to confirm which of those they want to take part in. So, before we move on to talk about that, it might be helpful for some of you if I explain how each of the different options for gathering evidence would work and what that might involve for people participating. Most straightforward would be further written submissions. I'd invite evidence in a matter, probably by asking a series of questions. This might be to the Park Authority and or to the appellant, but it could include other parties. And then after the initial responses are made, the parties have a chance to follow up with a reply or a response in writing. A hearing is a round-table discussion. That would be chaired by me. I'd invite everyone participating in a hearing to set out their position on the identified subject matter in the form of a written hearing statement a few weeks before we had the hearing. I'd then issue a more detailed agenda based on that hearing, based on the hearing statements. But again, the purpose is simply to fill in the blanks for me so that I can write my report. You wouldn't need to be professionally represented by a consultant or a lawyer, but people can if they wish. A public inquiry session is more formal. Each party sets out their statement in a written recognition of up to 2,000 words. This can be read out at the inquiry or taken as read, and parties can be led, for example, by a lawyer or advocate, but you don't have to be. After reading your recognition, you'd be subject to cross-examination by the opposite side, by their lawyer or advocate if they have one, and I might also have some questions. So an inquiry is a bit more formal than a hearing and perhaps more adversarial. So hopefully that helps, just explaining what each of those processes means. Now, I'll stop talking in a moment, hopefully. Before we go on to item 3, I think it's worth dealing with item 4 first, and that was where I raised the prospect of like-minded parties joining forces. Given that there are so many parties who've stated they wish to be involved, I'd like you all to give very serious consideration to that. Hearings and inquiries can run much more efficiently if people are able to come together and present a unified case. It can mean less work for those involved. It allows those most comfortable with speaking in public to take the lead, and by collaborating, people can often put forward a better and more comprehensive case than they can do separately. I can write a clearer and better report to ministers, probably. I'm not compelling anyone to get together, but I think it's worth considering seriously. If we need to have a break in the meeting, then that might provide a time to start such conversations, but parties can, of course, discuss these matters themselves after the meeting. Okay, so bearing in mind today is just about process, does anyone have any questions or comments before we move on to deal with item 3? Sorry, I've come out of the meeting. Okay.
Sir, just before we move back to item 3, we did have some thoughts on item 4, but I don't know if you want to hear those now or you intend to come back to it.
No, that's fine. Let's hear that now then.
So, obviously, no difficulty at all from the appellant's perspective if parties want to join forces, if you like, provided normal rules of evidence and submission of case are followed. But given the number of parties that did express a desire to take part, we wondered if a public session, an open floor session, might be a useful way to allow people to do that. That obviously happens in Section 36 wind farm inquiries not infrequently, where sometimes after the finish of a hearing or an inquiry session during the day, there's a session after that where people can come and make representations, and I think we wouldn't see a difficulty with that. It might be quite an efficient and effective way of allowing people to do that. From our perspective, all we'd ask for is sort of sight of what people were intending to say in terms of evidence and the opportunity to respond.
Okay, and are you thinking of that in addition to some of these other things or instead of some of these other things?
I think it would be not exclusively instead of. So if there are parties, I'm conscious Mr. Campbell is obviously instructed here and his client, so I expect will want to participate in the more formal sessions, but it would be as an alternative too for those who don't necessarily want to take part in the full process. It would be an opportunity for those parties to make representations to you without having to necessarily sit through a whole inquiry or hearing session.
Okay, it certainly was something I thought about, and I will think about it. So Mr. Welton's suggestion is sometimes, as he identifies in wind farms, we have wind farm inquiries. We have had a session where, rather than having a particular focus or subject matter, those interested members of the community who want to come and talk about a proposal can come and do so in a slightly less formal manner, and it doesn't. I don't think I've never done one. It doesn't go quite as far as a round table discussion. It's more of each person, if I'm understanding this right, saying what they'd wish to say, and that might involve questions that the applicants or indeed the Park Authority could respond to. So if we bear that in mind as a possibility.
Sir, could I address you on that? I'm not entirely sure what's being meant here, because I haven't personally participated in a procedure like that. But in terms of where the appellants are here, they are pushing for an inquiry on the topic of effects of wild salmon, which is the sort of appropriate assessment, habitats regulations appraisal. It certainly seems to me that there's a lot of participants here who would like to, give evidence in that regard, sir. Some of them are not obviously the Park Authority. We have the various trust organisations here. It's a matter for them, sir, but they may find that a hearing procedure on the topic of the effects on wild salmon is more inclusive and preferable on their terms. So I think maybe worthwhile just putting that to them, sir, because I'm not sure they would want to be sidelined from the main debate, shall we say, if it were to be an inquiry on HRA appropriate assessment. And the Park's position, sir, that we consider that the effects on wild salmon should be dealt with by way of an inclusive hearing, sir.
So it might be solved just simply by having the microphone closer to you. Is that speaker working in front of you? So there's one in the chair immediately in front of you. I don't know whether you...
I'm not aware of it. Yes. Okay, thank you. Okay, well, a reminder for just if we can all, I'll come back to you in a moment as well. If we can all try and speak up. Yes, I mean, we'll come on to each of the different subject matters. For me, there will be a balance between having the ability to test technical evidence, but also I do want to make sure those who want to participate can do so. So that I'm just going to have to take a balance in that. It might be that, and we'll come on to it. It might be that I've identified other matters. It might be that I've excluded matters from my list of things that other people want to talk about, and the kind of session that you suggested, Mr. Wilton, might work for that. But I'm still, if something like effects on salmon is quite technical in nature and legalistic, perhaps, then I'm still mindful of how I can best get to the bottom of the point. But I do take your point about inclusivity, Mr. McKee. Given the amount of people who've said they want to take part, it's an important factor here. Mr. Wilton, did you want to? So just to clarify, the suggestion, it was in terms of very much of item 4 on the agenda, and like-minded parties presenting their case in a way of facilitating that. It's not, certainly wasn't being proposed to deal with the technical aspects, and it's not an attempt to sideline anyone, as I think was being suggested. So it's simply in the context of item 4.
Might I say something, sir?
Yes, of course, Mr. Campbell.
Good morning. I'm John Campbell. I've got 2 clients in this case who are residents of Ardentini, so a very small part in the process. However, picking up on Mr. Welton's suggestion, if I may respectfully say so, it's a very sensible one, and one which is now well tried, particularly in Section 36 inquiries. It involves sitting usually in the evening, which not everybody loves, but it is a good way of dealing with people's personal points of view. You should know that considerable attempts have been made to corral individual objectors under one umbrella. It's not up to me, of course, to go out looking for business. That's not what we do, but nevertheless, those attempts do not seem to have been successful so far. Perhaps after today and looking at your agenda, there may be a change in that. However, this is not the first time this matter has been raised, and so far the objectors are a disparate group. Just so happens that I represent 2 of them, but there are others who are self-representing. So the idea, just to sum up, the idea is, in my respectful submission, a good one. It's quite workable. People write their statements out, and it forces them, therefore, to concentrate their thoughts on paper, and then you have that information later to report to ministers. Thank you very much.
I'll get you a microphone in a second. And when you do, sorry, if you could please just give me your name before you start, just so as I know who's speaking.
Thank you. So my name is Hilary Wharton, and I'm representing a group called After Clyde. And we do represent the views of a number of people and organisations around the Loch. And obviously there are other individuals and people who've objected as well. I don't understand what you're talking about, I'm afraid, so I wonder if you could perhaps elaborate a little bit more about what's actually being proposed.
So what Mr. Welton's proposed, yeah. So, well, I haven't been involved in such an inquiry either. But in my item 3, the format here is by subject by subject, and then me choosing what or suggesting what I thought was the best kind of means of handling. I think what Mr. Welton's talking about is in inquiries we've found some people don't like taking part in overly formal procedures. Some people have found it better and have found themselves more able to participate if they're able to come along, often in an evening, and read out a statement or say what they want to say. That might involve the appellant responding to some of those points, but it tends to go no further. It's still taken into account, but there's not a cross-examination process. There's not a detailed discussion to and from. It's an ability for someone to say what they want to say, and then that's the end of their participation, if you like. Whereas a hearing or an inquiry is more involved. It's more of a round-table discussion, views and opinions being tested, if you like. So I think that's. I'll come to you second. That's Mr. Welton's suggestion. What I need to think about is how does that work for this inquiry, and it might not be until the end of the day when we've went through these other different subject matters and I hear how people want to participate in that I can take a view as to how that's going to work. Did that help in any way as an explanation?
It did help a lot, thank you. I just want to make sure and be clear that it wouldn't preclude any involvement in the further proceedings.
No, I think the suggestion would be that it's just another way of doing it for some people. But yeah, so as I said to Mr. McKee, I need enough information to write my report, and where things are technical or where facts are disputed, then something like a formal inquiry is often better to get to the bottom of that. But there's a balance there between not excluding people who feel too daunted by a procedure like that.
Sorry, James McLean, Cove and Kilcreggan. Just to clarify that, right, are we proposing that there's a meeting that discusses all the issues that we're talking about, or are we saying that this is a meeting where you come and talk about a single issue as you put down in your list? So that's all I'm trying to clarify.
Yeah, well, yeah, that is what we have to clarify. I think I suggest we go through each of the items that I've identified, and we can talk about those in the context of the conversation we've just had. Where I've got particular questions and where there's matters that I really want to get to the bottom of, I'm going to have a public hearing or an inquiry to do that, because it's about what people want to say, but actually it's also about what I need to get out of the evidence. So I suggest we go through each of these items, and then we can maybe reflect at the end of that process on how this other idea might fit into that. It might be that sweeps up the things that are not covered in the more subject-specific sessions, perhaps.
Sorry, so is that what Mr. Welton is saying we should do?
Well,
sorry, I'm probably not being clear. Is he saying we should have an open meeting where everybody can come and talk about wild salmon, can talk about visual impact, can talk about, so you have a multitude of subjects within that hearing, or as is on the list, you deal with one thing at a time?
From there we go. Past experience of how these sessions have worked in other inquiries is it is an opportunity for people who want to talk about one matter or a number of matters to make a statement to the reporter, to the inquiry, to put their evidence across. It in my experience, is not. In fact, it almost invariably will touch on the same items that are being dealt with during the more formal hearing or inquiry sessions. But it's for an individual or somebody representing a number of individuals to make that representation on whatever matters they think are relevant.
It's working as. I just want to be clear. Not having a good day here so far. Can you hear me? Yeah, that's working fine. So I just wanted to be clear in this sort of hybrid proposal that if members of the public or third-party representatives participate in it, are they excluded from then participating in the more formal hearing or inquiry sessions? And when they do, if we have this less formal forum, who participates in that? Does the Park Authority and the appellants? And is there questioning? Is it run like perhaps a less formal hearing? And that's probably why I'm just sort of concerned about, that there may be technical evidence coming from, for example, the Salmon Trust organisation, which is of a technical nature, sir, which may not lend itself to, a less formal session or less formal than a hearing session. That's my tuppence worth on that, sir.
Okay. Yeah, I mean, those are things I'm going to have to think about. I wouldn't anticipate excluding anyone from anything. The way Mr. Welton described it, it sounds like you would have a hearing session or an inquiry touching on a particular subject, but if someone didn't want to participate in that but still wanted to do it in a different way, then they would come along in a different session and be able to say what they wanted to say, and that might not get into the level of detail of the discussion about a hearing, but nevertheless it would provide that person the opportunity to do so. I'd anticipate the appellants would be there at a session like that, and presumably the Park Authority as well. But yeah, that I have not done it before. That would be my understanding of what's getting proposed, and Mr. Wilton's nodding. So, okay, so let's keep that in our minds and perhaps move on. To each of the bullet points in number 3 in the agenda. Is that okay for everyone?
Without wishing to...
Sorry, I just want to know who's speaking, please.
Sorry, my name's Colin Liddell. We share a name, sir. I'm the current chairman of the Loch Lomond Angling Improvement Association, and by association the Loch Lomond Fisheries Trust. My only concern with the suggestion about the open meeting or the round the hall meeting is that somehow the key issues get diluted in terms of time management and focus and attention, and perhaps not get into the level of data and detail and evidence, because it sounds like an emotional platform rather than an evidence-based platform. So I think the agenda management would need to be very, very precise. Thank you.
No, thank you. No, that's a point well made. My job is to write a report to ministers, and the purpose for me of having a further session is to get the evidence I need. So that's my. I won't not have a session that doesn't allow me to get that. So if you, for example, wanted to participate in a hearing which was getting into the technical matters, and it sounds like that would be the more appropriate format, rather than come along to this other thing and not be given that opportunity, if you like. Okay. So, the first, I'll go through to the bullets in item 3 then, if everyone's fine. The first thing there is scope of other consenting regimes. Now, I should probably explain what I mean by that. So, it's an established principle that, generally speaking, the town planning system shouldn't be used to control matters which are covered by other consenting regimes, other legislation. So a straightforward example would be things like the structural engineering of a building, its internal appearance, or its internal construction. Those are for a building warrant and not planning permission. That's an easy example. Fish farms, though, because they involve planning permission in the marine environment, and particularly are subject to a range of other consenting regimes. So, from reading the evidence, I understand that this proposed fish farm already has a licence from SEPA under the Controlled Activities Regulations, which would control the discharges to the water environment. And in granting a licence, SEPA considered the effects on the benthic environment, so seabed ecology, but also on water quality. It would require a marine licence, which I understand is related to effects on navigation, and I'm aware that there are other regulations which relate to things such as the welfare of farmed fish, perhaps about use of medicines. If an effect is controlled by another regime, it might not be relevant to this appeal, which is only about planning permission. So my thinking was that I would ask probably appellants in the first instance, although it needn't be just them, to set out in writing their own position on which aspects of the development and its potential effects are controlled by other consenting regimes, and what that means for their relevance or otherwise, because there can be overlaps, of these matters for this planning appeal. And then I'd invite the Park Authority, unless it wanted to respond in the first instance, and other parties to respond to that. It's just so as I can be clear in my report to ministers what's relevant for this appeal, what's not, and also what's relevant to this appeal, but it's also covered by other regulatory regimes like CAR. I will come back in, but I'm going to ask the appellant and the Park Authority first for their views on that. And I was thinking further written submissions would suffice for that.
So yes, from the appellant's perspective, we have no difficulty with that. We'd be more than happy to provide a written submission. I think written submission is the appropriate way to deal with this particular issue.
Thank you, sir. The Park also consider that to be a sensible suggestion. May I take you up on your first suggestion that the appellants set out the other consenting regimes first in writing, sir, and then the Park Authority and other participating parties are given, a reasonable period to respond to that, 14 days, 21 days, whatever is suitable.
Okay, thank you. Mr. Liddell, did you want to say something on that point as well? Sorry, Jane, you're doing a lot of walking around with the microphone, so thank you for that.
Thank you, sir. I just wanted to, it was really a point in question. The key part of the Lomond catchment system enjoys SAC protected status, which requires or places a legal obligation on anyone presenting a risk to the system to demonstrate fully how they plan to mitigate against such risks, given the protected status. I just wanted to ensure that that was taken into account in any consenting framework as to how the applicant plans to mitigate the legal responsibility for causing no harm to two of the species covered by the SAC status.
Okay, so that's wild salmon and lamprey, isn't it? Those are the two, yeah. I'm not going to get into any of the pros and cons, but yeah, part of that first bullet in item 3 is to try and make sure I'm clear about the parameters for the consent, if you like, or not consent or otherwise. But the item, I can't remember whether it's which bullet it is, but the effects on wild salmon. One of the reasons that the Park Authority refused the consent was because of its concerns about the effects on the SAC. So I don't, whilst in this bullet I'm trying to set out the parameters, if you like, I don't anticipate that will tell me that effects on the SAC are irrelevant. I'm sure they are relevant, and I need to consider them. The Park Authority consider them. One of my sessions is focused on that, so that I'd anticipate we'd have to get into that, or I'd have to report on it certainly. Okay, people don't need to say today whether or not they wish to participate in this. I think for each of these, the meeting note will set out what further procedures and how they're going to take place, and then at that point, everyone would have the chance just to confirm in writing whether or not you wish to participate in those. Does that, on that first bullet point, is there any other questions about process before we can move on?
And I don't know if this is anything you have any flexibility. So Hilary Wharton, Arthur Clyde. Somebody mentioned a reasonable time to respond being 14, 21 days. And I think for people in professional capacity, absolutely that seems reasonable. But for members of the public who are trying to sort of rally responses around communities, that's pretty challenging. So just a request that be taken into consideration when you're setting timelines for responses.
No, that's a perfectly fair point. Our default tends to be 14 days. When it's over the school holidays, I tend to make that 21 days because there's a balance between I need to progress this but also making it inclusive. What did you have a number in your head that you?
I mean, I think 21 days would be the minimum.
Okay, it might not be a big issue. We'll come on to decide. We'll come on to talk about what dates we can all have these sessions, and we tend to work backwards from those. So actually, if it's a long lead-in time, I hope it's not too long, but if it's a long lead-in time, then that should allow enough time for us to stage those things so that people do have enough time to respond. But we'll come on to that. Okay. So the second point was it's called the nature of the development. Now, this was suggested as a hearing session by the appellant. I think with a view, and we've already touched on it, with a view to explaining to me how this type of fish farm and its technology is intended to operate. Now, I think I understand that from reading the written evidence, but I am conscious that a lot of the representations focus on the fact that it's would be novel to this country. And that comes out in the Park Authority committee report as well, and in some of the statutory responses from statutory consultees. Just bearing that in mind, Mr. Welton, from the point of view of the appellant, do you want to say any more about why you think this would be of value, or would this be morphing into the open mic session, if you like, that you were suggesting?
I don't think it would, sir. You've obviously got our further submission of the 1st of March this year, which sets out the appellant's position on procedure, and I would simply reiterate what we've said in that document about why we think it would be appropriate to have a hearing session on the nature of the development. We've heard Mr. Liddell this morning, the other Mr. Liddell, if I can, touch on the technology issue, and I think there would be benefit for you, for ministers, for everyone participating, to have that session. I would suggest it would be probably the first session, because that would then allow people to understand the nature of the proposal in more detail. It wouldn't be it wouldn't be one for the open floor session. I think it would be at the start of the process, and that would allow the appellants to explain the proposal, address some of the criticisms that have been made by the Park Authority and others, and then of course allow people to ask questions.
Okay, so it sounds like you would be the only ones that were actually. It would be all talk. It would be you explaining the project, if you like, or the technology, and then others being given the chance to ask questions, rather than other people coming with their views. Is that how you see that working?
Yes, in part, it's the nature of. There are criticisms that have been made. The Park Authority have made a number of criticisms around the technology, which they then rely on for their decision, but we have their conclusions, but not their reasons for those criticisms. So, as things stand, I'd agree it would be for the appellants to explain the nature of the development, the proposal, how the technology works. If of course, if others have a counter view on that, then they could provide evidence on it.
Okay. So that would be your part of it, but equally well, you see if other people wanted to come with their statement or their concerns or however you would describe them about how the technology works, they would be doing that as well. Okay. And for all of these things, there's the inevitability of some overlap between some of the other sessions, but if we're going to do this, I can see the value in doing it first, because it's about fact gathering, if you like, or information. Mr. McKee, from the Park Authority's point of view.
Thank you, sir. The Park Authority's view is that a hearing session isn't particularly necessary for this, sir. I'm not aware there is a great dispute about what is being proposed here. Yes, it is the first in Scotland. It is novel, but that's a factual statement more than how it works, sir. I certainly am of the view that this could be dealt with by further submissions if needed.
Okay, and in terms of the criticisms, and we don't want to get into them, but it's just about the scope here. It seemed to me that the two concerns emerging from objectors, if you like, and the Park Authority, to a lesser extent, one of them maybe, was the risk of escape related to technology, which we could deal with, or would be dealt with, in the session on effects on wild fish, and the other point raised in some of the submissions was about control of sea lice and the effectiveness of the technology in controlling sea lice, which might also be relevant to that session. So I'm just trying to think: is it sufficiently different from that?
I think it is, sir, because what the session would, as you said, it would be a fact-gathering exercise. I don't imagine it would take particularly long to do, only a couple of hours, and it would be to gather the factual evidence on what is proposed before then getting into the more detailed sessions on what potential impacts might be. The difficulty from the appellant's point of view, the criticism that comes from the Park Authority, is that they say that it's technology not tested in Scottish waters, and they're unpersuaded by submissions made by the appellant that adherence to technical standards would be sufficient. And the purpose of this hearing session will be for the appellants to be able to address that point. And I think it would be of benefit to be able to do that separately from the considering of the evidence on the HRA SAC point.
Sir, could I just address you on that? Because the point that my friend has made is I thought was the very point that was to be covered under bullet point 4, which is the effects on wild salmon, sir. I mean, the principal dispute between the parties is the efficacy of the technical standards and whether that will lead to an unacceptable escape risk. I thought that's what we're dealing with under wild salmon, sir, not under the nature of the development. The nature of the development, I thought, was really the sort of physical elements of the development. As we know, it's got the sort of the entry to harvest element, and it's also got the sort of post-smolt aspect to it. I rather thought it was going to be around that, so it has its operation, not the adherence to technical standards.
Okay. Sorry.
Sorry, James McLean again. I think it might be helpful. Can someone just explain the difference between a hearing and an inquiry, and what that means in terms of participation from objectors or supporters? Because I'm a bit confused. Thanks.
Sure. No, of course. So, in terms of upfront work, not necessarily that different, in as much as if we were having a hearing, I'd invite everyone who's coming along to a hearing to write their position statement on the subject matter of that hearing, which I could probably get from reading your representations anyway, but it's just encapsulating your case. If in an inquiry session, it's a written statement. It tends to be typically 2,000 word statement. Okay, and in both of those cases, if you've got other documents you want to rely on or refer to, you can produce them. That's fine. But the hearing would be a round table, and I would chair it, and I would have taken everyone's hearing statement, and I would have thought, well, what else do I need to know? Where do I need to ask questions? And so I'm really trying to get to the bottom of people's positions in a round table format. In an inquiry session, it's more court-like, if you like, in as much as you would read your recognition, and if you were an objector, then you would be cross-examined by Mr. Welton, rather than me chairing a meeting on a round-table basis. And I might have questions as well. So it's designed to really stress test the evidence. An inquiry is designed to really stress test the evidence where the opposing side is in a better position to answer questions, if you like, or should have the opportunity to really stress test someone's evidence rather than rely on me questioning it on their behalf. Mr. Houghton. So before I carry on, it's fine. But I was going to suggest that we just carry. I'll just need to think about this, the potential role of this kind of session, and it might be that I'll be better able to do that once we've talked about the posited session on the effects on wild salmon, because there is certainly would be overlap. Sorry, Mr.
Good morning. Yes, my name's Paul Houghton. I'm here for representing an objector whose particular interest is the technology. Obviously, I've heard what Mr. Welton has said, and obviously the nature development point would pick up on technology. And then I've heard what Mr. McKee has said and others. And then it seems as if it may come up again in the effects on wild salmon. So you'll have this sort of almost slightly odd situation where we'll have discussed the thing at a hearing, and then potentially we can discuss it again as part of a formal inquiry session. It seems to me, and as far as my client is concerned, he considers the technology warrants an inquiry session, given the fact that it's so central to the appellant's case, and obviously it's so central to a number of the other issues you're going to go on to discuss, which obviously flow from that particular session on the technology.
And when you say the technology requires an inquiry session, it's efficacy, it's suitability, if you like, yeah?
Yes.
Okay, I think someone else wanted to.
That direction, we can't hear you. I just wondered if you. I just think it's ridiculous that there's not a microphone for each of you that works. And if you put it in the middle a bit more, then maybe I just can't hear you when you turn that way. Sorry. It should be the other.
Okay. I think I'm just going to have to reflect on the value of that. But that, discussions we come on to have might help me do that. Okay, so the next item I identified was seascape, landscape and visual effects, a hearing or inquiry. So the appellant suggested an inquiry session in this topic, whereas the Park Authority suggested the hearing. So I intend to visit all of the viewpoints in the EIA report. I've already visited some of them, and the supplementary landscape and visual impact assessment on my own. I do that on my own, and view the site from nearby roads and paths. We'll come on to talk about the site inspection and whether I can do that informed by the site being marked out. But in terms of methodology, there's disagreement about effects and their severity, if you like. But in terms of methodology, what I could discern, the main disagreement between the Park Authority and the appellant seems to be about the status of the weight given to the seascape and landscape assessment of the Firth of Clyde. So it doesn't feel like there's a lot in there for an inquiry session to me. I've dealt with various wind farm inquiries and had inquiry sessions on landscape and visual, but ultimately in landscape and visual matters, I'm going to have to make a judgment as our ministers. And the other thing I'm mindful of is who else wants to participate in a session on landscape and visual effects, and would they wish that to be, would they find it easiest to get involved in a hearing session or an inquiry session? So I'm going to actually go out and ask people, sorry to do it so crudely, but I'm just going to ask for a show of hands. If I have a hearing or an inquiry on landscape and visual effects, can people in the room just raise their hands if they want to be involved in that? Right. So that's 4 people, 5 people, 6 people, and so it's just a straw poll. I'm just trying to understand. And if you prefer a hearing session, can you put your hand up? Okay. Sorry, sir. Yeah, carry on. Right. So a hearing would be round table, quicker probably, and less formal, less adversarial. I don't want to use that word too much, but certainly, Mr. Campbell, I'll come back to you. I can see your hand up. Thank you. Whereas at the inquiry, it tends to be more formal evidence. However, I don't want to overplay that. So, for example, a landscape architect giving evidence could anticipate being thoroughly cross-examined by a lawyer or someone else on the opposing side. A member of the public telling us all what they think about the landscape and visual effects, not professing to be an expert, shouldn't expect the same level of cross-examination, if you like, than the expert would get. So I don't want to overplay the kind of rigour of it in that sense. But it's just a different way of getting to the evidence, if that explains it.
Could I just ask the lawyers on this, which would they
sorry, if we just wait to the microphone, just so as if we don't wait for the microphone, it won't come up in the audio recording.
As lawyers representing an objection, I would like to ask them their advice, what they would say would be better from a public. I mean, I'm just one of the public rather than a body, so I would like to ask you. Sorry, I don't know your name.
I was going to say maybe we can do that. Maybe that can take place if we have a break, and maybe worth having a break anyway at some point for people, because that's really I wouldn't want to be involved in that kind of discussion. Mr. Campbell.
Yes, sir. Can you hear me?
Yes.
Yes, good. My clients are indifferent whether there's an inquiry or a hearing, but I would endorse what you say about the ability of the reporter to get more information more quickly if you have a hearing. and it's a lot easier on members of the public. I mean, Loch Long is what it is, and the landscape, we all understand it. So it's just a matter of looking at the impact of the proposal on that landscape, which need not be a wholly expert matter. It's our intention, for what it's worth, to lead a landscape architect as part of the case being made by my clients.
We'll get you a microphone in a second. Ironically, we could have probably done this in a round table format. I was expecting all these seats to be filled today.
I had put my hand up for the inquiry, but having listened to the gentleman on the screen, I would like to now change it to a hearing. So if you did another poll, I would say hearing. Thank you.
Okay, thank you. Yeah, I mean, it's people needn't feel they're. Ultimately, I'll need to make a decision on what I think's best. Sorry.
Yeah. At what point will you address the land use issue as to whether it is actually permissible to use the land in this way for an industrial development?
So, I'm not sure exactly what you mean by that, but I suppose to the extent where that's relevant to the planning, the policies in the National Park Plan, the National Park Local Plan and the Partnership Plan, then that may be relevant. I don't see the need for any. I'll take into account everything that's relevant to the planning consent, but I don't see the need for any further sessions.
Well, this is actually public land with a history. I believe that there are legal constraints on the use of the land.
Yeah, and so I've seen that written evidence about when it was given or bequested. So I've seen that. I just need to reflect as to the relevance of that for my report. So I can't say any more than that. If it's relevant, I will take it into account. If I don't think it is, then I won't. Okay, so there's perhaps up to half a dozen people in the room certainly would want to take part, whether it's a hearing or inquiry. Mr. Campbell's expressed his client's views. I haven't asked you yet, Mr. Wilton. So what do you think?
So, in my experience, I've seen inquiry sessions and hearing sessions both prove very useful for getting landscape and visual impact assessment evidence. There are clearly technical issues in dispute. There's issues of dispute in professional opinion. It sounds like we'll have, I suspect, at least 3 professional landscape architect witnesses involved, for what Mr. Campbell just said. Taking all that in the round and looking at what the guidance says in terms of appropriate procedure, in our view, it does lean towards an inquiry session, but equally, I can understand why you might prefer to do it by hearing. I don't think we'd have any particular difficulty with that approach in this case.
Okay, thank you. And Mr. McKee, what about the Park Authority?
Thank you, sir. Whilst there is a dispute on these matters, clearly the dispute is not particularly of a complex or technical nature. It's certainly the Park's view that a structured discussion led by the reporter through a hearing session would be the appropriate procedure for this, and is more likely to focus on the issues that you, sir, would like to hear upon. It may also prove to be more inclusive to the relatively large number of interested parties who will also wish to participate, sir.
Okay, that's fine. I'm probably just going to think about it. Is there any other final comments on this particular matter in terms of process before we move on? No. Okay. I'm just looking at time. It's 11 o'clock. We'll maybe keep going for a little bit further, but if people feel need of a break, then just please let me know and we can stop. We're making better progress than I thought we would, so that's good. Though this now may prove to be the longest session. So, effects on wild salmon. One of the Park Authority's reasons for refusal relates to concerns about the risk of escape of farm salmon, and these then genetically interacting with populations of wild salmon in or migrating to and from the Endrick Water Special Area of Conservation. And further evidence on this point is potentially technical and legalistic in nature, hence why my thinking was that an inquiry session might be needed. So just thinking about the SEC at the moment, for the appellant, Mr. Welton, do you have anything to... And I've seen what you've said in writing, but is there anything to add?
No, so I think we've set it out in our note of 1st of March.
Which, for the benefits of those who haven't seen it, I don't know if you just really briefly explain.
Yes, the appellant's position is that in respect of reason for refusal, they're not actually numbered, but reason for refusal 3, which I think you've just referred to, is the appellant's position that that given the legal and technical nature of that reason for refusal, this is one that falls foursquare within being appropriate for an inquiry session, and that's what we are asking for.
And what, Mr. McKee, I think the Park Authority, if I get this right, I think you felt a hearing was sufficient for that, didn't you? Is that right?
That's correct, sir. The dispute, just translating it down to sort of brass tacks, really concerns the efficacy of the technical standards, and that was a matter which was not considered by the Park to be particularly technical. It is a matter of presenting the facts, and yes, there will be interpretation of those facts. We don't see any reason why that shouldn't be a structured discussion led by yourself, sir. I would also make reference to the sort of 2 recent planning appeals. One is PPA-002-2033, which was the one in Lochranza, Brodick, Isle of Arran, which is actually referred to in the appellant's own case. The other one, sir, is PPA-270-2224, which was at Bridgend, near Bridgend Cottage in Portree in the island of Skye. Both of these appeals, sir, concerned the same issues that's before the inquiry here, which is impacts on landscape and seascape, and also impacts on an SAC with HRA and appropriate assessment in play. In both of those appeals, the reporters did not engage any oral procedure at all. I think there was some minor further procedure, sir. So it wasn't felt necessary in similar appeals, including one referenced by the appellants themselves, to have any procedures. So for us to ask, to suggest a hearing would be going further than these other reporters have gone. They're different cases. I fully accept that, sir, but I just cite that as an example. So that's 2 reasons why it should be hearing. The other one is really down to the point about the number of interested parties who may wish to participate. The Atlantic Salmon Trust, as one example, they may find a hearing session more inclusive process. So I suggest that you ask them. I don't speak for them. But that's the part. A hearing would be sufficient and suitable and provide in order to make judgment, sir.
Okay, I could hear that, but I'm not sure everyone else could necessarily. It was breaking up. Can we maybe change the microphone, please, just for Mr. McKee? Please.
Thank you, sir. My name's Alistair Reynolds. I'm the chairman of the Argyll Fisheries Trust. And today I'm also representing the chairman of the Argyll and District Salmon Fishery Board, Roger Brooke, who was unable to attend today. I think it's quite likely that one or both of us would like to make representations to you. I think from what I've heard, our preference would be for a hearing rather than an inquiry. So I'm Argyll Fisheries Trust. That is not the same as the Atlantic Salmon Trust, which is a different organisation.
Are there any other comments in the room, Mr. Liddell? I suspected you'd want to say something on this.
Yes, I want to say something too about this, please.
Colin Liddell, Chairman, Loch Lomond Angling Improvement Association. I, with the greatest respect, disagree with Alistair. Being largely data and evidence-based by career, and otherwise, it sounds very much to me that the inquiry route deals far more on a evidence-based and data-based discussion, unless I completely misunderstood, than a round mic session or a hearing where it may come down to opinions or statements rather than facts, data, evidence, science.
Okay, thank you. And you should both be able to deal with data and science. For me, for my role in it, am I able to am I more able to get right down to the bottom of something rather than leaving it to the professional advocates to do it? That's their training, if you like. And when matters are technical or legal, that they tend to be better at it than a reporter is, if you see what I mean. But Mr. Campbell.
Yes, thank you very much. It's a moot point whether my objecting clients will enter the lists on this question, but in my respectful submission, I agree with Mr. Liddell and I agree with Mr. Welton that this is an inquiry topic of the first importance. And likely to be the one that will cause you most difficulty, I think, in the range of subjects which you have set out. Certainly the evidence I've gathered so far indicates that. Thank you very much.
Okay, thank you, Mr. Campbell. Mr. Liddell.
Sorry, I'll be brief. It's maybe an overarching concern or maybe a lack of knowledge on my part, but in terms of where this appeal sits, how does it align with the current Scottish Government's policy with regards to the climate and nature crisis? And will that be taken into account by yourself, with due respect, in terms of your final report?
It would be, insofar as the National Planning Framework is the recently published statement of Scottish Government planning policy, and it has policies, I can't remember which numbers they are, they might be 1 and 2, that say how the planning system should address the nature crisis. So there is a policy requirement on me to take that into account. I mean, it's as much as I can say at this point, but it's a relevant consideration. Yeah, a relevant consideration for me. Okay. So, in my proposal was whether it's a hearing or inquiry. Its scope, so far as I've written it down, is about the effects on the special area of conservation. But I just wanted to give people the opportunity to tell me if they think that's too narrow. So, and that's about the risk of escape. So, the session, as I see it at the moment, isn't dealing with sea lice effects, and isn't dealing with effects on other populations of wild salmon. However, I know there are salmon rivers in Loch Long. I just want to know if there are any views as to whether I should widen that out to be wider than the SEC. And that's the other one then.
Sir, I for one would want the scope expanded. Given the historical performance of this industry and its impact on the migratory fish populations on the west coast, I believe it's absolutely key that you take into account the wider environmental impact, such as sea lice infestation and sea lice nurseries in such close contained farming. For example, our association has commissioned and works closely with Glasgow University and SEAM, and they have undertaken extensive studies into habitat impact, which we will be glad to share, including smolt migration tracking in terms of routes and mortality. So yes, I think it should be widened.
Okay, Mr. Reynolds. Yeah.
Thank you, sir. I would just echo what Mr. Liddell said there in regard to widening the scope beyond the SAC, and point out, as you've already observed, that there are several rivers entering Loch Long and Loch Goil, which are highly relevant to this particular appeal.
So Hilary Wharton, F. the Clyde. I'm minded to actually agree that it should be kept just not to consider the lice, actually, because I think if we bring the lice debate into this discussion, it takes us into a discussion about the merits or demerits of the semi-closed technology and the impacts of that in terms of lice. So I would actually say we should concentrate just on the risks for the SAC and keep it focused on that.
Okay. So there are. It's complicated for me to try and work my way around what's the best way to do this. But there are two things. So there's even if one excludes, I'll come back to even if one excludes effects on sea lice from the session, are there still risks to other salmon populations from escape as well? So there's two different things for me to think about. But I think I know where people are coming from. Those who've spoken. I know this wasn't part of the objection from part of the reason for refusal. I don't think from the Park Authority. So I'll come back to you in a second, Mr. McKee. But Mr. Welton, if you haven't heard that discussion, have you got anything to add in terms of scope?
I have to not particularly, sir. We, as I said in our submission in March, the focus of the reason for refusal is the impacts on the SAC and the parks finding of an adverse impact on integrity in terms of the HRA reg. So we are quite content to focus on that. I think the comment that's just been made perhaps does sort of bring out why there might be benefit in having the nature of development session at the outset to help set the context. I think it's perhaps showing that dealing with that issue first, understanding the nature of what's being proposed, and then moving on to the more detailed sessions on the potential impacts might help guide the evidence for you, sir, and keep things clear.
Okay, thank you. Mr. McKee, is there anything to add?
Sir, I'll start by saying I don't think it would be helpful to have a sort of an early nature of development session dealing with sea lice to get it out of the way. You're quite correct that the Park Authority's reasons for refusal are focused on the impacts on the integrity of the Endrick Water SAC, sir, and that is its main focus. That having been said, the Park Authority are not objecting if the interested parties wish to expand the scope of what you may have intended here, sir, to deal with the effects of sea lice on salmon, not just in the Endrick, but obviously in the other migratory rivers from Loch Long. So we have no difficulty if they wish to include that in that particular session.
Okay, that's all clear then. Right. I think, unless there's any other... Oh, sorry, Mr Campbell.
Sorry, just to say that self-evidently the nature of the development with respect to the national park is not their topic because they haven't dealt in their reasons for refusal with the merits or demerits of what is proposed. They're simply looking at the effect on the park. But for the people who are living around the park, the nature of the development is paramount. So if Mr Welton is tacitly proposing that there be an opening session on this particular bullet point, I would wholeheartedly endorse that. Whether my clients are able, because they have done some work on it, but whether they're able to muster the necessary technical expertise in time remains an open question, but they will certainly be trying to do that. And if there was an aggregation of interest, third-party interest around this point, then that would seem to me to make good sense. Thank you, sir.
Okay. Well, yeah, I think Mr Welton's suggestion was more than a tacit one. He led with it, but that's fine. I'm going to have to think about all this and how it all fits together. Sorry, Mr Welton.
Sorry, sir, could I just come back very briefly on a couple of points that Mr McKee made on behalf of the Park Authority. The first, in terms of the two appeal cases he referred you to, my understanding is that neither of those had an adverse impact on integrity as a reason for refusal, so I'm not sure there's a huge amount can be taken from those. The other point is that the appellant's position is not is in terms of reason for refusal 3. This isn't simply a point of technology. The appellant's position is that the Park Authority have failed to properly undertake its appropriate assessment, and the appellant would wish to cross-examine the Park Authority on its approach to that, which we regard as a technical and legal matter. So it's not simply about technology, it's about what underpins reason for refusal 3. And I think from the perspective of you writing reports are to the ministers, we do have quite an unusual situation here where a finding of adverse impact on integrity has been made, and it's been made without following the advice of ministers' own advisors on this issue, Nature Scott. And for those reasons, we would say that being able to test that evidence through cross-examination will be the most effective way of dealing with it. Whether we then have a separate session dealing with the non-SAC points, if you like, and that could be dealt with by hearing so that it's inclusive for others, I think is something which the appellants would be happy to facilitate.
Okay, thank you. Can we move on to the next point? Are we all okay? So hopefully we can deal with these last two bits under number 3 quickly, and then I think I'll give people a break. Are we okay to continue for a little bit more, or do people want a break now? Okay. Okay. So planning policy. I have, through the initial appeal submissions, the views of both the Park Authority and the appellant as to what planning policies apply and to what effect. That includes National Planning Framework 4, which I mentioned, which now has replaced Scottish Planning Policy. So, in that sense, I wonder whether there's any further exchanges of evidence are even necessary. Excuse me. have you got the appellant got a strong view in this?
So we don't see there being disputes as to which policies apply and the interpretation of those policies. So if you needed something further on it, very happy to provide further submissions, but I would agree.
Okay, sorry, I had my microphone there. Sorry, the Park Authority as well.
Thank you, sir. I take a different view on behalf of the Park, sir. The appellant suggests that planning policy is relatively straightforward and there's no dispute. There is a dispute about the interpretation of the policies, sir. I think what's relevant for you to bear in mind, sir, is that at the time the Park Authority's board meeting refused the application, the National Planning Framework 4 had not yet been adopted. So we now have two development plans forming the development plan, sir. And that in itself raises some issues in terms of the interpretation of these policies. And to take that matter a bit further, it's not just these two components of the development plan. We've also got the National Marine Plan, sir. We have the Clyde Regional Plan. There are other sort of related planning policies which are also relevant. So quite a mosaic of planning policies. There's a further matter on top of this, sir, which, although not in your kind of expression of what is planning policy, the Park are also bound by the terms of the Sanford Principle, which is enshrined in the National Parks Act 2000, sir. And I thought that, together with planning policy, should form the basis of a hearing session, which I think should happen at or near the front end of this passage of evidence, of oral evidence. And the reason for that, sir, is understanding where the parties are truly in terms of policy sets the framework against which the other matters such as landscape and visual, seascape impacts and appropriate assessment can be judged. Certainly in my experience in other inquiries and where hearing sessions are being used, there has been an early session where planning policy is a little bit more than above average in its complexity. So it's always complex, but there's quite a lot happening here. And it's not accurate to say that the parties in any way agree on the interpretation of these policies. There's a lot of disagreement, particularly around the interpretation of national planning policy, National Planning Framework 4. I think it would help, sir. It would help rather than we'd be jumping back and forward, I think, you know. And it would be a time saving to consider that, not necessarily park it, but consider it and understand it a lot better before we move on to the other elements.
Did you want to come back on that?
I think so. If you were minded to have a session, I'd agree with Mr McKee. There would be best value in having that up front. I don't hear anything there that suggests to me it can be done through written submissions, however.
Okay. Mr McKee, is there a particular reason why further written submissions wouldn't suffice?
Well, sir, I suppose if one were to look at your own reporter's guidelines as to when it would be appropriate to have a hearing, I mean, there's two issues. One is if there's a divergence in view at professional level, which clearly there is in terms of interpretation, and also might that reveal evidence that you need to have before you to make an informed judgment. So my view is it would be better, rather than parties, you know, firing documents at each other saying this is what it means and others saying no, this is what it means. It might be better to have a session where you can test the planning officers on the particular disputes around the policy that you need to hear evidence on, sir. And I actually think it would be time efficient.
Okay, so in that model, I would have a hearing statement from both and from others who wanted to participate, and then we just have a hearing where I could pick out where the disputes seem to be. Yes, sir.
No, that's it now. Thank you. I want to come back to the issue of land use as a rubric, because it's not only about, say, maybe the legality of the land use, but it's environmental, recreational and heritage aspects of that particular site that's proposed. Regardless of the merits of the technology of the fish farm, is this the right place in terms of a planning decision? And I think that enough time and attention needs to be given to that key aspect of the land use, whether it is permitted to allow a development on this particular site. And there's evidence, Forestry and Land Scotland, as a government agency, are the custodians of this public land. They have a management plan for that site. The site is a pause in terms of the plantation of ancient woodland. In their own plans, already there was a proposal for the rehabilitation of that area. So I hope that there will be adequate opportunity to look at the whole business of the appropriate use of this land at the site of the proposed development.
Okay, thank you. Yes, I mean, I've seen all that written evidence. It's before me already. I just need to contemplate whether I need to know any more about it, or whether I'm sufficiently well informed already to write my report to ministers on the subject. I mean, that holds for all these issues. Okay, I'm going to move on then to the final part on this agenda item, which was planning conditions and obligations, and hopefully this isn't too long. So I have a list of proposed planning conditions and obligations from the Park Authority. I've got the appellant's comments on these. My thinking at present was to invite those two parties to see if they can reach agreement on the conditions and any obligations to be applied to apply if permission is granted. And they could then update me on what further progress had been made in reaching that agreement. If there isn't agreement, then that's fine. I would just need to take a view on where there was a matter of dispute. We could have a slot for a hearing if we needed it, because sometimes that can be useful to iron out disagreements, if you like, or get further explanation of them. And just to explain, regardless of my recommendation, I have to have a list of proposed conditions for ministers, because they might want to refuse the consent, they might want to allow it, and if it's the latter, then I need to tell them what conditions I think should be applied. So it's not a we do it in all these types of appeals. So does that sound? I'm hoping that sounds sensible and normal practice.
Yes, sir, that'd be absolutely fine with the appellants, and I'd agree that having a short session, usually at the end, to have a round table round the conditions is actually, I agree with Mr McKee on this point, in terms of being the most effective and speedy way of dealing with it. It allows you to sort of iron out any issues, so that appellants would support that approach.
Mr McKee?
Thank you, sir. The Park Authority are content with your suggestion, sir.
Okay, thank you. And if anyone else, usual thing, the note of meeting will explain what's going to happen. If other parties wish to comment on the conditions that are proposed, then they can tell us that they want to do that, and we'll give you that opportunity as well. Okay, so that covers. I'll have a break before we go on to timings, which hopefully will be a bit quicker. But that covers all the issues that it seemed to me need further evidence. I've already heard what you've said about land use, and so I'll take that away. There are a range of other matters which have been raised in the letters of support and objection: economic benefits of the development, road traffic effects, noise, odour effects, and tourism, other effects. So I haven't excluded them because I'm going to ignore them, or because I don't think they're important. These and various other matters are going to be relevant, and I'll take them into account. The reason I've not put them on the agenda today is because at this point I think I understand the points being made and can take these matters into account in my report without seeking further evidence. However, if you think that's wrong, then I want to hear about it. So I don't know if anyone else. You go. If we can get a microphone to you.
Thank you, sir. It's probably in the documents that you've already read about, but I'm just wondering whether an important factor is water quality and health. Everybody's talked about landscape, efficiency of the system, etc. But we have a water course here that is one of the most highly polluted water courses for microplastics in Scotland. There's also the risk from our nuclear facilities, etc. And recent reports have come to light that there have been quite a lot of discharges into the loch. So I'm quite concerned that water quality and health, i.e. raising food in an environment to then feed us, is dealt with in a proper way. Thank you.
Okay, so I'll go on to you in a second, Mr. Houghton. So I'm still in the process of contemplating all of this. In terms of water quality from an environmental point of view, that might be relevant, albeit there's the car licence, and I need to understand how those two regimes interact. In terms of, is this a fit enough environment for growing food for human consumption, that doesn't sound to me like it's relevant to a planning application. I would have thought the Food Standards Agency or other regulatory bodies would be responsible for that, rather than me being in any position to be able to take a view on that as a planning professional. I could be wrong about that, and I'll think about it, but that's my initial reaction to that as a consideration. It doesn't sound like it would be relevant to my report to ministers on an application for planning permission. But I don't have a closed mind on it. Mr. Houghton.
Thank you, sir. I appreciate you're going to touch on the site inspection in point 7, but just under your any other matters, obviously, sorry, going back to my point, which I've been asked to come here about the technology, and obviously the central question is it tested or untested technology? And obviously in a lot of the evidence presented by the appellant, they reference, for example, its use elsewhere. And I was just wondering, and my client was wondering, whether you were thinking, or whether you thought it was important to make a decision on this, that you actually saw this technology in operation, and I didn't know whether the appellants had any comments on that. My client has certainly, with regard to this and another site that the appellants are obviously considering for this same technology, has raised this matter with them. And I was wondering, sir, whether that was a matter that it might be important for you to consider as well.
Okay, thank you. I mean, I hadn't contemplated that would be possible, since there aren't any. It isn't operating in Scotland, but I suppose it's operating elsewhere in the world, perhaps. But it's something for me to think about. I don't know whether the appellants get any. It was almost a question to you there, but on those last 2 points, have you got anything to add?
Well, so the appellants aren't obviously in a position to provide that by definition. I think perhaps on the second point about wanting to visit the sites, if I can come back after the break on that, or we can speak to Mr. Houghton about that direct, because I know it has been raised by his client before.
Okay, thank you. Yes, I wasn't asking for a plane ticket to Norway from you. That's fine. Okay. Are there any other, on terms of the scope of what I've suggested for further procedures? Are there any other questions? No. Okay. Good. So that's 11:45. Let's take a 10-minute break, just so as everyone can have some comfort, get some water if they need it. And then we'll talk about just the timetables for all of that, and hopefully we can get finished before lunchtime. Thanks very much, everyone. Are you ready to start again? Okay. Okay, I'm going to start the meeting again, if I may. Items 5 and 6, I'll maybe take them in reverse, and this is about the timetables and arrangements for the exchange of evidence, but also it seems highly likely we're going to have some hearing and or inquiry sessions, so we need to talk about when we can do those, and it's maybe better to do the latter one first. So and we can work backwards. I had put in the meeting note that I was hoping to be able to do this in August or failing that in September. And typically we've relied on parties to give us their availability, but I think we'd like to, in all these cases, we'd like to force the pace as much as we can. So it's not just about availability, it's about our obligation to progress cases, for ministers in good time. That said, I just, in the first instance, I want to hear from the two parties up here about availability. So, August or September, how does that sound?
Sir, August would be difficult, and I think also in terms of procedure, August might be challenging for parties, a number of parties involved in the procedure that will be required. September, I think, is something the appellants can support. I think we've got the timescales to do that equally. So last 2 weeks of September, first 2 weeks of October, we could certainly do that.
Right, so that's the weeks. For you, the best, is it the 11th, week of the 11th and then the week of the 18th of September?
So week of the 18th and week of the 25th.
Oh, sorry, my fault, yeah, of course. What about the National Park Authority?
So August is, like with the appellant, August is a difficult month, sir, and there is no availability really when we look at all of the availability of the parties. So nothing in August. September is looking better. We haven't gone into October yet, sir, because we only looked at August and September. There are some dates in September where we are all available. I think it'd probably be better if you're going to take the view, sir, that we strike out August and then move to September. It might be better if we went for particular blocks of days that are going to work, sir.
Yeah. So, and we'll come on to how long this might all take, and that's going to depend on the decisions that I make anyway. So it's quite difficult. But I'm just looking at our availability because our capacity to service events is also, depends on what else is going on. So in my note, for the week beginning the 18th, I'd written not Monday and not Friday. I think that might be because of public holidays. I'm not sure if that's the case. But if we were to take those 2 weeks, even if we didn't have the Monday or the Friday in the first week, that would still give us 8 days, which sounds like it ought to be enough, depending on the process we adopt. So, could we pencil in those 2 weeks and we could firm up the actual dates? But so that'll be starting on the 19th, right, through those 2 weeks for as long as we needed it.
Sir, unfortunately for the park, the Monday the 18th of September is not suitable for one of our principal participants, and it doesn't sort of free up. If you're looking at that, we don't really free up until the 25th of September, so, and I need to double check, I think, with parties if that moves into the first week of October. Sorry about that.
Right, so you said the 18th wasn't suitable, but then you said the whole week wasn't suitable. Yeah, so
I meant the week commencing the 18th, so the 18th right through the 22nd is actually, someone is booked off then, so.
Someone essential.
Well, it's the head of planning, sir. So.
No. I'm sorry, that leaves us with the 25th. you said, did you say you hadn't looked into that second week?
The week of the 25th, every day but the Friday the 29th is available, and I'll need to double check for the following week, the week of the 2nd of October. I appreciate Park Authority have to look at this. The 29th of September and the 6th of October are the day, it's the 2 Fridays. Essentially, we are unavailable, but it looks to me that we could do the week of the 25th and the week of the 2nd of October, minus those 2 Fridays.
Okay. And in the past, often inquiries have usually been 4 days a week anyway. Okay, so I'm going to proceed on the basis of those 2 weeks, and if people absolutely can't do it, then you can tell me quickly. But I'd like, we start to get very late after that.
Just to be clear, sir, we're talking about the 25th of September, the 2 weeks from the 25th of September. I think we're good in the appellants can't make the Friday, so we're fine for the first 4 days. We just need to check the following week, sir. And we'll do that as quickly as we possibly can.
Okay. I mean, so often I try and agree this with everyone, but it's just not going to be practical for me to find dates that suit everyone. So I'm going to propose that subject to that being doable, that we go for those 2 weeks, or up to those 2 weeks. I'll see if, well, I might as well talk about venues. My instinct is that we should do it, given that there are local people interested, it's best doing this in person or hybrid rather than virtually, but I don't know if anyone's got any views about that. Mr. Welton, first of all.
Yes, sir. We would support in-person proceedings, but accommodating hybrid where necessary.
And I'll come on to you, but Mr. Campbell, in case I forget, were you going to make a point about that?
No, I was just going to say I'm available for both those weeks. Happy to pencil in those 2 weeks. 4 days in each week.
Okay, thank you. Thank you. Mr. McKee, about virtual versus in person.
So in person, we're the Park are like-minded, so I'm happy with your suggestion.
Okay, and presumably for people locally, it depends. Some people prefer doing it in person, and some people prefer doing it virtually. But if we do a hybrid session, that allows the people to choose how they participate. Does that sound sensible to people? Okay, and I'm presuming we would try and book this hall again. That seems like a good venue, subject to availability. Okay, so in terms of the exchanges running up to that, I think we have that gives us plenty of time to make sure there's enough time for people to submit further written submissions to respond to those. So I would aim to send a note of the meeting out by the end of at some point next week. I would send a note of this meeting out. I would I'd give people 14 days simply to confirm. That would set out what the plan is, what procedures we're going to run, and would give people 14 days simply to tell me which procedures they want to be involved in. I would issue a request for further written submissions following on for that, and make sure there's enough time for people to respond. So the two things we have to talk about are dates for the exchange of hearing statements and recognitions, but also for documentation. Mr. Welton, do you think there's already a lot of documentation already because there's on the file? If I ask for hearing statements, do you think that can be at the same time as documents being produced, or does one have to come before the other? I'm not sure what people think is the best way of doing that.
I think, sir, documents usually includes reports and expert reports. So what we'd ask for is early hearing statements, early statements of case, so that we can understand the scope of the case being made by other parties, and that then would help inform if any other documentation is needed. So I think what we'd ask for is a relatively early date for submission of hearing statements of case, whatever we want to call them, setting out the parameters of people's cases. We'd obviously do likewise, and then documents with expert reports would follow on from that. I think if we do it simultaneously, you're going to find almost inevitably a request for further documents to be provided once we understand the case that we're facing.
Sorry, and if that's an inquiry session, or even if it's a hearing session, that's a three-stage process, isn't it? Then you have a statement of case, then you produce documents, then you produce your recognition or your hearing statement, which is fine if we can accommodate it, but I don't want to overcomplicate it for people if I can. Are people's position statements not apparent already from their representations, their consultation responses, their decisions?
I have to say, to be frank, that's no. Not from where the appellants sit. On the three-stage process, the final stage of that, the recognition or the hearing statement, is very often, particularly recognitions, is almost invariably a cut and paste from an existing document. So it doesn't tend to in itself be a significant piece of work, and of course that would be for those participating in inquiry sessions.
Okay, we can try and work back from the dates to talk about timescales. Mr McKee, though, does the Park Authority have a view on that? I was hoping to avoid statements of case, but maybe that's just unrealistic.
I think it's really a matter for you, sir. I mean, we obviously want the efficient processing of the inquiry or hearing, depending on how they are, sir. It would be, certainly in most cases I've been involved in, there has been statements of case, either an outline and then detailed ones, so there may have been even a stage beyond what you've just said, so a four-part stage. I'm not suggesting it. In terms of whether statements of case are needed, I think the main issues of dispute between the parties are fairly set out in some considerable detail in the passing documents, sir. So it's almost the full particulars are there. They just need to be outlined, I think, sir. So I'm not wedded, is what I'm trying to say, to statements of case being absolutely needed here.
Okay, let's just do an exercise then. What did we say? It was the 25th of September, wasn't it?
25th, yes.
25th. So that would require, if we started on the 25th, then you would want precognitions and certainly hearing statements in by 2 weeks before that, which is the 11th of September. Documents 2 weeks before that, which would be about would that be the 28th of August or something like that? And then that would require statements of case to be, let's say, 2 weeks, the 14th of August, and we could elongate them if we want. So I could set this out in the note, but it sounds like there's plenty of time to do that.
I've said, without putting any pressure on you, sir, if your note was to come out next week, I'd calculated that gives us 14 weeks from, say, the 19th of June through to the start of the inquiry, which I think is quite a chunk of time to be able to put statements of case, documents, etc. in place. I think we've got enough time to do that.
Okay. I mean, I'm happy to go along with that. I just don't want it to be overly onerous for third parties to have to repeatedly give me, things in different chunks. Okay. So rather than set out, because we have enough time, I can probably just come up with a timetable, I think, rather than have to go through it just now. And I'll try and allow time, hearing what's been said earlier on about for third parties being given enough time to respond. Also, it's over the summer, so that might have implications. So I'll take account of that when I'm doing the timetable. We can come on to talk about closings. We can deal with closing submissions later on, but one of the innovations, if you like, that we're trying to do in our reports is rather than you have me summarise your statement of case or your position, what I think I will ask everyone to do at the end of the process is to summarise again, and it's asking you to do even more, but it's to summarise your case, and then I would simply cut and paste that and put it into my report as an appendix to the report, let's say, so as that when I'm telling ministers what parties' cases are, it's coming directly from them rather than from me spending weeks, which it can take weeks, summarising different parties' cases, potentially getting it wrong, and so forth. And I could focus on the kind of reasoning after that. So you needn't worry about that just now, but I'm just saying that's what I'd like to do at the end of the process, because your case might be. Hopefully your case will be different having gone through the process. You might want to adapt your case. Okay. So I think possibly the only other thing that I wanted to mention on that agenda, on that issue rather, was just about documentation. So it wasn't the case during COVID, but now I think the Park Authority has to have documents on deposit again when there's going to be an inquiry or a hearing, and if members of the public want to view those, the Park Authority has an obligation to be able to facilitate that. So I just mention it as something that we'll probably ask for you to confirm how that will be done, and whether that's online or at the office. I'm not sure how it works exactly, but I'm just flagging that as an obligation on the Park Authority. Okay, and in terms of, I think in terms of we have potentially up to 8 days over those 2 weeks. I think it's too early to try and work out a programme just now because it's going to depend on what process I adopt. So we'll just have to park that particular issue, and then I'll come back to parties to see how I think it might work. But certainly I would be hopeful that those 8 days should be more than sufficient. Okay. Is that okay? I was planning to move on to site inspection then, if that's okay. So, as I said earlier, I think I can do most of the site inspections unaccompanied, and I understand that for the Park Authority Board, the site was marked out with boys, perhaps, was it? Anyway, there was an indication of the extent, I think, of the marine element of the development, and the board members visited by boat, I think. So I suppose, was that help? No, that maybe I've misread that. Okay, I've been out and I walked down to the site yesterday from our garden, so I've been there. But I wondered though, when I'm viewing it from other locations, would it be helpful to have it marked out in some way so that the extent of the marine area was possible?
So for the park visit, what we did is we marked out the shore base facilities where things would lie, and the marine enclosures, we marked the centre of those and the corners of the site. It's not an insubstantial undertaking for us to do. And it takes a bit of time because we've got to, let a contract for somebody to go and do that sort of work, do all the safety stuff, and then we've got to organise retrieval. But we have done it before, and we could do it again if you felt that was necessary. It's
difficult. So that was for the Park Authority board members when they visited physically on the site then, and so they were looking at this being there on the shore base side of it.
Yeah, so they went to one viewpoint at the Three Lochs Way junction, and then they took some buses down and walked down to the shore area and did a site inspection in the shore area. And in that context, what we had laid out was some signs saying that this is where the officer would be, this is where the oxygen cylinders would be, those sorts of things.
Right. Oh. So that side of it, perhaps less so. I think I have a fair enough understanding with looking at the drawings when I was on site as to where everything is going to be, and I'm not asking. I don't want you to go to unnecessary expense. My question is, will it help me write my report to ministers? Will it help me be better informed about the landscape and visual effects? If, for example, I can be on some of these higher level viewpoints in particular, looking down and be able to understand the extent of development, or are the landscape and visuals enough already? I don't know if the Park Authority's got a view on this, because your members, whether they got something out of that when they visited.
Yeah, in terms of it's as the appellants have described in terms of the kind of the process we went through with members. I think particularly from a landscape point of view, to mark out as was for board members, I think it's important to help, because you made the point about the judgment that you need to come to. So to understand in effect the extent, I think is important to be aware.
And is that the marine side of it, or the
particularly the marine side? I would say, yeah.
Can I just say, so in terms of the marine components, when we deploy those buoys, that is a hazard to navigation. So we need to let folks know that's there, and then the time needs to be as short as possible, so we can, it suits us best if it's a single day, because then we can have a vessel on site that can deploy and retrieve. That's what we did with the park visit. But if it needs to be longer than that, then of course we would facilitate that. So just whatever you require, but it helps us. The shorter the time, the better. Thank you.
Okay. I'll think about it. I've never asked this to be done before, so I don't know whether it would be useful or not. I think as I was envisaging it, then it would be, we would select a day or 2 days or whatever it was, maybe just before the inquiry, and then that would, having the benefit of viewing the site with those on site, just might help me at the inquiry. But I can't insist on you doing that.
Just to flag on the practicality, sir. I think it's sort of a 4 to 6 week lead-in time to do it, and it is also weather dependent. I got told earlier, so there's that to just, if you can bear that in mind as well.
Yeah, well, I'm conscious of that. It could be, if it's misty, then it'd be completely abortive in any event. So yeah, okay, yeah, or choppy. Okay, I'll have a think about that then, and at most it will be a request to consider it. It's not something I could or would insist upon. If I need to make my judgments without it, then I can do that. So, as I said, I've already been down to the site itself, along the forest tracks. I'm comfortable that I don't need to do that on an accompanied basis, but if people think it's essential, then I'm certainly happy to do it. Park Authority happy with me attending on my own, or?
The Park Authority are content that you attend it unaccompanied, sir.
Okay, that's great, thank you. So I've covered everything I wanted to cover. Before I close the meeting, I don't know if there's any other questions or comments that anyone has.
So it's just one question I had actually is, ministers are now the competent authority for the appeal. As I said, we're in a slightly unusual situation here. I won't go back over it, but we're in a slightly unusual situation here with the terms of the appropriate assessments being undertaken. I just wondered if there was any sort of information or guidance from you on how ministers yourself are going to fulfil your duties as competent authority in terms of undertaking an HRA assessment.
So, as I understand it, ministers would do that on the basis of having had my report. Typically, I think other reporters have, if they've had to deal with HRA as an issue, they've signposted ministers to the particular parts of the report or their conclusions, which underpin their own conclusions in terms of those effects, but still leaving the formal HRA to do by ministers. How ministers go about that process after they have a report, I have no idea. Is there any other points, anyone, or questions? Oh, yeah, I beg your pardon. Yeah. Sorry, so the habitats regulations appraisal. Yeah. So the formal assessment required of the effect on a European site. So it's that would be ministers would do that formal process. Having had my report. Sorry, was there another question? No. Anything else? Okay.
Just to understand what it means, are the Scottish ministers acting as a corporate body legally?
They are acting as the planning authority in effect. So they.
Well, yes. They also happen to be the custodians of public land. But my concern is here. Normally, with planning matters dealt with by local authorities, I hear councillors on the planning committee say they must not in any way declare their views in advance of their decision. Now, if the Scottish ministers are a corporate body, and maybe someone like Mr Campbell might advise on this, the fact is that one of the Scottish ministers has already declared his support for the application. So that seems to me highly prejudicial in a setup where the Scottish ministers have the final say. So, what is the legitimacy of that process if someone within the Scottish ministers is already taking sides?
Well, I have no knowledge of that, or which minister has said anything.
Mr Robertson.
Right. I've been appointed to report back to ministers on the planning merits of the case, and that's what I'll do. Any questions about that procedural aspect you raise about conflicts of interest or that, or things of that nature are not for me. I wouldn't do anything about them or get involved in them. That would be a question for ministers rather than for myself, I think. Yeah. I couldn't comment on that.
Probably more for my own understanding, but I'm assuming an HRA is a mandatory step in this process, and I just wanted to ask, if it's not already been carried out, when will the HRA, if it is indeed, if the process is contingent upon there being one, when will the HRA study be completed, and when will that information be released?
So, to my best understanding, the national, one cannot consent a project which has, I may get the words wrong, which has a significant effect on a Natura site without first undertaking an appropriate assessment or habitat regulations appraisal. If you don't consent the project, you don't have to undertake one of those assessments. If you do wish to consent the project, you have to apply the test and the habitat regulations appraisal. The Park Authority did that. It's an appendix to the committee report, I think, and then refused the application. My understanding, if ministers were to wish to consent this, they would have to undertake a habitat regulations appraisal. They would presumably do that on the basis of the evidence that was in my report and the documentation. But that would be it's an obligation on the decision maker. So it is done at the point of which, or prior to making the final decision. If there are better explanations from people in the room, then they can tell you. But that's my understanding of it. Okay. Any other questions before we close the meeting? Okay. Well, I just want to say thank you very much, everyone, for your participation. I will. I'm putting pressure on myself. My aim is to get the note of this meeting out by the end of next week, and that will both invite you to confirm how you wish to participate. It will also set out my expected timetable for the exchanges of written evidence, and indeed the dates and time, the start date of the inquiry session. As for how we populate those several days, I think that might come a bit later, but we can do that when we need to. So, thank you very much, everyone.